Greetings, I am Eunice Mutami, a second year student at Africa University. I am doing a presentation on specific situations of negligence under the law of Delict. So I'm going to start with the introduction. The law of Delict is primarily focused on determining liability and compensation for harm caused by negligent actions or commissions. So negligence arises when an individual fails to exercise the level of care accepted under specific situations in the law of Delict, devolving into the complexities and nuances of determining liability and awarding damages. Negligence refers to a failure to exercise reasonable care that results in harm or injury to the next person. So negligence is a principle in the law of Delict which holds individuals accountable to their failure to exercise reasonable care, thereby causing harm to another person. So we are moving on to the legal principles that determine negligence. Duty of care. It establishes that individuals have a legal obligation to exercise reasonable care to avoid causing harm to individuals, as it's owed to individuals who might have reasonably be foreseen as being at risk of being harmed by one's actions. Another legal principle is reasonable foreseeability. It is whether a reasonable person would have foreseen that you owed a duty of care, for example, in cases of professional negligence. Another legal principle can be causation, where there should be a link between defendant's breach of duty and the harm suffered by the plaintiff. The defendant's conduct must be the proximate cause of the harm. Remoteness considers whether harm suffered by the plaintiff is too remote or to defendant's actions to be held them liable. So, continuing with the legal principles that determine negligence, the plaintiff bears the onus of proof to prove that the harm suffered was a reasonable foreseeable consequence to the defendant's breach of duty caused harm suffered on a balance of probability that the defendant's negligence caused harm. Contributory negligence arises when the plaintiff's own negligence contributes to their harm and damages are shared proportionately. In cases of occupiers' liability, occupiers have a legal duty to take reasonable care to ensure that their premises are safe. In cases of defective products, principle of product liability comes into play, where manufacturers, distributors, and sellers are subject to strict liability of their defective products. So there are various negligent activities which may include careless driving, dangerous conditions on land and buildings, defects in manufactured products, faulty design or construction of buildings and bridges, improper medical care, inadequate control of a dangerous animal, professional negligence by lawyers, accountants, auditors, careless handling of dangerous substances and firearms. So these are some of the activities under negligence. So another specific situation of negligence can be when defective services by garage and inadequate maintenance of vehicles. A garage may be liable in Delict for harm caused as a result of negligent failure to carry out a properly repairs to vehicles. For example, a garage undertakes to repair the brakes of a vehicle. A garage for a vehicle, if it fails to do the job properly, but it assures the owner of the vehicle that the brakes of his vehicle had prepared, the owner then fails to stop at an intersection outside the garage because the brakes could not work and collides with another vehicle. The garage can be sued in Delict by the injured parties. Yeah. So in cases where there were defective services, the plaintiff always has the onus of proof to prove that the garage, the ones who provided services, lacked reasonable care. For example, in the case of transport and crane hire versus David Hubert, 1991, defendant's company negligently assembled a lorry so that the steering wheel was incompletely assembled. After some distance, the steering failed. There was an accident and the lorry was a total write-off. The court decided that the harm was reasonably foreseeable and rejected the argument that plaintiff's failure to detect and repair the defect of the steering column was the proximate cause of the accident. So another specific situation of negligent can be negligent handling of labor matter by someone proposing to be an expert in labor matters. For example, in the case of Bigot and Violence 2017, the plaintiff engaged the service of defendant to present him in a labor dispute. Defendant, who held himself as a specialist practitioner in the field of labor law, failed to exercise the requisite skill and the diligence by an expert in handling a labor dispute, and this resulted in plaintiff resulting financial loss by way of having to engage a legal practitioner to resent an arbitral award against plaintiff. Defendant was therefore liable to pay for the loss that she had incurred. Another specific situation of negligence under the law of Delict is handling of heavy equipment. So, in the case of Rolefis versus M. Manchod and Sons, plaintiff was injured by a reversing front-end loader in a loading zone. Plaintiff was involved in a conversation and did not keep a proper outlook for the loader. The court found that the loader operator was not negligent, as he could not reasonably be expected to have anticipated such a likelihood. The company was thus held liable for the injuries of plaintiff. So, another specific situation of negligence by where security guard from a security firm failing to guard premises. When a security firm undertakes to provide security at a defendant's premises and assigns one of its guards to perform this duty. In the case of Geopa versus Facet Security, a security company contracted with an oil company to guard its premises. A transport company had certain vehicles on the premises as part of its contract with the oil company. One of the vehicles was stolen by an employee of the oil company and destroyed. The transport company instituted action in Delict against the security company, claiming damages in Delict for the loss of the vehicle, alleging the negligent breach by the security company of a duty of care owed by it to transport company to prevent the theft of its vehicle. The court held that the security guard was not negligent in failing to prevent the theft of the vehicle. In Modcraft Transport versus Voucher Security, a security guard was guarding premises and saw intruders on the premises and did not try to apprehend them or disturb them. He simply went and informed the company's security officer, who took a long time to respond. By the time he had responded, the intruders had already stolen property and got away. The guard's employer was liable in negligence for the theft. So it depends with the cases where one is held liable or not. I have reached the end of my presentation. Hopefully this presentation has helped you understand the specific situations of negligence. Thank you.